Good afternoon. Welcome to the Office of Tax Appeals. My name is Judge Turner, and I'll be conducting the hearing today. This is the appeal of Freeman. Before we get started, a couple of housekeeping items. Of course, first silence your cell phones so as we hopefully cannot be interrupted. We are being live streamed and recorded on the OTA Office Tax Appeals YouTube channel. And a copy of this recording will be available, and the transcript that will be produced therefrom will be available to the parties on our website. So when you're giving your presentation, be sure to be, clear and articulate. Make sure we don't talk over one another. Our transcript will be provided by our erstwhile hearing reporter, Ms. Alonzo. That should be available on our website. Also, be cognizant we are being live streamed, so don't share any personally identifying information, social security numbers, that kind of information, addresses, that sort of thing. Just be cognizant of that as you're giving your presentation. Also, just to ensure we have a clear record, just be sure that you speak clearly. Don't talk over one another. My job here as the lead is to make sure that we have an orderly hearing. And so it's possible I might interrupt if we get it sort of out of order or something like that, or just for clarifying purposes. But again, the whole idea is to so that everyone has the opportunity to be heard here today, and that we can produce a clean record for us to consider in our deliberations. A reminder too, we're not a court. We are an administrative tribunal. We are staffed by tax experts. And we are in our endeavor to try to create a proper record and orderly hearing. We may ask you to repeat yourself just for purposes of the hearing. And my role here is really just to conduct the hearing. I'm joined by my panel members, Judge Stanley and Judge Elsom, and we are equal participants in this process. And after the hearing, we deliberate, and we will jointly produce the opinion. And that opinion will be produced within 100 days of, assuming we close the record at the end of the hearing, 100 days of the close of the record. So with that, introductory matter, any questions before we proceed on the record?
Not for me.
No,
Wonderful.
I'm good.
Excellent. So if everyone's ready to proceed, let's go on the record. This is the appeal of Freeman. OTA case number is 241117905. The date is January 15th. The time is approximately 1:03 p.m. The hearing is being held electronically upon agreement of the parties. As I mentioned, I am Judge Turner. I'll be the lead for purposes of conducting the hearing. My co-panelists, Judge Elsom and Judge Stanley, are here, and they are equal participants in the deliberation and determining the outcome of this appeal. If I could have the parties introduce themselves, starting with appellant.
That's me.
Yeah, go ahead. Go ahead.
Peggy Freeman.
I'm Karma Welchel, CPA.
Respondent.
Good afternoon. This is Tristan Thalhuber, and with me is Brad Coutinho on behalf of Respondent Franchise Tax Board.
Excellent. Stated in the minutes and orders, our issue today is whether appellant timely filed a claim for refund for the 2019 tax year. Is that everyone's understanding what the issue is today?
Yes.
Excellent. Exhibits. Appellant had submitted exhibits 1 through 6. Respondent submitted exhibits A through F. No objection was made by either party to the exhibits presented. I'm prepared to enter those into evidence unless there's an objection by the parties right now. Do I have any objection from anyone on the exhibits that were referenced in the minutes and orders?
No.
Wonderful. Then those exhibits will be entered into the record. Witnesses, appellants, Ms. Karma, I believe you are representing the appellant. Are you intending that the appellant present testimony today?
Yes.
Okay, then we will, Ms. Freeman, we will have to place you under oath before your testimony begins, which I'll do so momentarily. Just as an order of conduct, appellant, you'll have 15 minutes to present your testimony. Respondent will have 15 minutes to reply, and you'll have 5 minutes in rebuttal. We may have questions after the presentation. There's an opportunity for respondent to ask questions of the witness. And so we'll provide that opportunity when her testimony is complete. And then we may have questions for appellant or the witness or the respondent, just so you know at the end of the testimony, we may or may not. And so just to be aware of that, you'll have 5 minutes for closing remarks after the hearing. So with that, before we begin your testimony, your presentation of the appellant, I'd like to place the Ms. Freeman, I'd like you to be sworn in as a witness so that the testimony you're about to give can be used as evidence by us in our deliberation. So with that,
Okay.
you do me a favor, please, and raise your right hand. And do you swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth? Please say yes or no.
Yes.
Wonderful. Your testimony will be considered as evidence, and any testimony you give throughout the presentation today will be treated as testimony in the record. So thank you for that. And with that, Ms. Karma, I presume you'll be presenting the main arguments for appellant. So if you would begin, you have 15 minutes.
Yes. So Peggy is going to go ahead and let you know the timeline of what happened for this appeal. Go ahead, Peggy.
Sometime in 2024, my sister called me and said that she had received a letter from the state of California indicating that we had overpaid some taxes on my mother's sale of my mother's home. I had not received the letter at that time. And so I said, well, what are we supposed to do? And she said, I don't know. But she goes, I'm going to contact my tax preparer and take the paperwork to her and see what we need to do. And I do believe I finally did get my letter from the state of California. I think it was February of 2024. So my sister said, you need to do the same. You need to take that letter to your tax preparer and have him, fill out these forms, what have you. And more information was needed from the escrow company, which we did get. And I do believe that is part of what you folks have there. And so I took it to my tax preparer here, and he sat on it, and he sat on it, and he sat on it, and he didn't do anything with it. And when I contacted him, I said, where's the paperwork? Where's what's going on with this? And he said, I don't know how to make the numbers match. So he said, I can't do it. So therefore, my sister and I both went back to our 2019 tax preparer that prepared that year's taxes, and he sent us amendments to the 2019 tax repair. And that is what we sent to you folks, to California, but we were late. And I was late because my tax preparer here sat on it and didn't tell me he did not know what to do with it. And it was then that I contacted Karma after all this went on, and she helped me with it. And my sister, and she did the same,
So your assessment, the state of California assessed that Peggy was late in her filing because she did not file by the amendment until after April of 2024. However, the statute section 18564 does allow for a granting of an extension, which is an automatic extension. So we are claiming that she should have basically until October 15th of 2024 to file the return. Also, code section 19306 also says that unless before the expiration of that period, the franchise tax board allows a credit, makes a refund, or mails a notice of proposed overpayment on the pre-printed form prescribed by the franchise tax board. She received that notice the end of February 2024 and basically had a month and a half, 2 months and a half to get something together, to contact her real estate people to get the form so she could file the amendment. So she did not have enough time, but she did receive that notice, and we feel that she should have had more time until the October 15th, 2024 filing deadline.
Is that the end of your presentation?
Yes, that's the end. Thank you.
You just, Ms. Freeman, I just had a real quick question on, I want to make sure, when you went to your first CPA, was it, I want to understand when you said that they had advised you that they weren't capable of filing the return, or that you didn't have claim to it?
I moved from California to New Mexico. So it
Ah.
was my preparer here in New Mexico that I gave the information to. And like I indicated, he sat on it and did nothing with it. And unbeknownst to me, not knowing tax stuff, after, I didn't hear from him, I finally got a hold of him. And he said, I cannot make the numbers match. So I can't do anything with it. So
What
I
it
went,
was,
excuse
go
me.
ahead.
So I went and picked up the form, and then, I spoke with my sister about it, and my sisters told me, she goes, my tax preparer told me to go back to Dennis Cooper, who was our tax preparer in 2019, and have him do it, have him fix this up for us. And so that's what we did. I went back, I called him, and he told me to send him the stuff, and then he redid it and sent it to me, and he told me, send it to California, certified mail with signature. He said, you're already late, but he said it might help if you send it certified mail with a signature. And that's what I did.
Thank you. Before I move on to my panel members, respondent, do you have any questions of the witness?
I do not have any questions. Thank you.
Thank you. Panel members, Stanley, Mr. Elson, do you have any questions for either on the presentation or of the witness?
Hi, I did have one question, and this would be for the tax preparer, Ms. Karma. You had made a statement, or possibly this was the appellant's. I just wanted to clarify what you had meant when you referenced a pre-printed form. Was this on an FTB letter, or were you making a reference to a law or a ruling or something of that nature? Can you just clarify?
Yeah. It was section 19306, which talks about the period, the extended period. And the last paragraph on that is where it talks about mails a notice of proposed overpayment on a pre-printed form. So it's actually in the code section.
Okay, so but by that
19306.
you're referencing the unclaimed withholdings
Correct.
letter. Okay.
Yes.
Okay, thank you. That was my only question.
Ms. Stanley?
This is Judge Stanley speaking. I do have one clarification question for Miss Freeman. You said that it was withheld on the sale of your mother's house. How did it get reported under your social security number?
Well, my mom passed away. So the home went to my sister and I when she left. And I don't quite understand. the question. I mean, my social security number's on all my tax forms,
Okay, so the house was sold after it was transferred to you and your sister?
Correct. Yes.
Okay, thank you. That explains it.
Respondent, you have 15 minutes to present your side.
Thank you, Judge Turner. Again, this is Tristan Thalhuber on behalf of Respondent Franchise Tax Board. The issue in this appeal is whether the appellant has established that she filed a timely claim for refund for the 2019 tax year prior to the expiration of the statute of limitations. Unfortunately, the evidence will show she did not as to the barred overpayment. Appellant timely filed her original 2019 California tax return on April 13th, 2020, and as such, the 4-year statute of limitations expired on April 15th, 2024. Appellant filed her claim for refund in the form of an amended 2019 tax return over a month after the 4-year statute of limitations period expired. The only payment on appellant's 2019 tax year account is her withholding credit, which is deemed paid on the original due date of her 2019 tax return, and thus the 1-year statute of limitations is unavailable to allow a refund of the overpayment for the 2019 tax year. Appellant contends that her tax preparer overlooked the relevant withholding credit on the closing statement of her 2019 California property sale, and that FTB did not notify appellant of her unclaimed withholding credit. However, reliance on a tax preparer does not negate a taxpayer's responsibility to file a timely claim and does not extend the statute of limitations. Furthermore, FTB has no duty to discover a taxpayer's overpayment or notify taxpayers of such overpayments. In its precedential opinion in the appeal of Benemy Partners, the Office of Tax Appeals held that the language of the statute of limitations is explicit and must be strictly construed. The appellant has not provided any evidence that would allow FTB by law to grant her claim for refund, and therefore FTB requests that the Office of Tax Appeals sustain its claim for refund denial for the 2019 tax year. Thank you, and I am happy to answer any questions.
Thank you for that. Panel members, any questions for respondent?
No questions from me. Thank you.
This is
Stanley.
This is Judge Stanley speaking. I don't have any questions at this time.
Thank you. Appellant, back to you. 5 minutes for closing remarks.
Yes, so we do not dispute that the tax return was filed, the amended tax return was filed a month after the original due date. However, the statute of limitation does give a little bit of leeway when it says that it will say that it can make a claim after the notice on a pre-printed form prescribed by the Franchise Tax Board. That is part of the statute of limitation wording. And that's all.
Thank you. Well, we appreciate your participation in our hearing today. We will consider this case submitted to us on January 15th, 2026. The record is now closed. Thank you all for participating. The judges will meet and deliberate and decide your case, and we'll issue a written opinion within 100 days of today. Today's hearing and the appeal of Freeman is now concluded. Thank you for coming.
Thank you.
The OTA